quite realize the Sunday afternoon, and we've had a heavy day yesterday. As you all know, there was a launch of the Arbitration Bar of India, and so this 45-minute session, while the topic is the recent development in the arbitration law and what implication it has for India, I think all of us can speak for 4 hours and given enough time. But we only have 45 minutes, and we'll try to keep it interesting and very conversational. We'll try and have some audience Q&A at the end if that works. So how we'll do this session is it'll be very conversational. So I'll be asking questions to my panelists, and we'll be taking their views on various developments which we think are relevant for today's discussion. I mean, arbitration is one area where after 2015, we have seen consistent developments and major amendments. And when we talk of development, it's not only legislative developments which we talk about. We'll also talk about a lot of judicial development in clarifying the arbitration law on various aspects. And I mean, the discussion on recent developments in arbitration cannot really be started without talking about the expert committee report, which recently came out, which suggested multiple developments in the Arbitration Act. Why the expert committee becomes extremely relevant is the committee was comprised of all the stakeholders from the industry, from the law firms, the lawyers, the government. Everyone sat together, pooled in their views. The institutions were invited to give their views. So, and I want to start right away, and I want to ask Arush on the aspect of the expert committee report. Do you think there were hits and misses in the expert committee report, and do you want to just summarize the developments and the suggestions there?
Thank you, Samir. It's an honor to be here and sharing this dais with people I admire. Well, as you said, the expert committee report, firstly, in my view, they do recommend some path-breaking reforms, and I would highly recommend all aspiring arbitration practitioners to give it a read. In the interest of keeping it short, I'd just like to highlight some salient amendments that have been recommended and probably just dive into the pros and cons. I think first and foremost is the elephant in the room, which is the proposal to introduce the concept of an emergency arbitration in India. They've recommended the insertion of 12 capital B, as per which institutions would now be permitted to, in that sense, to have emergency arbitrators who will then have to pass his or her award within a period of 30 days. Now, of course, it is a very, very laudable initiative, and I do hope it's implemented, but I think they could have maybe widened the canvas from just being constricted to institutional arbitration, perhaps to even move into ad hoc arbitrations, where parties may perhaps have agreed in their arbitration clause to have a named emergency arbitrator. Perhaps, I mean, just thinking aloud, because right now the concept of EA is only being proposed to be in, there in institutional arbitration, which is also good because it kind of promotes the concept of institutional arbitration and steer away slowly from ad hoc arbitration, which has plagued the landscape for the best part of last 25, 30 years. Number two, I think to introduce the concept of TPF in India. Historically, under the common law principles of champati maintenance, they were prohibited in India. But now to embrace modern day economic realities, these concepts have watered down and also been abolished in a lot of common law countries, England, Australia, even Hong Kong for that matter. So I think to get third party as a concept in India, I think we need to thank Shashank for that firstly, because I think he got the ball rolling when arguing the SBS Holdings case. So yeah, I think we all owe a note of gratitude to him for that. But third party funding, well, again, I think it is a reform which is required in India. But TPF as a concept needs to be first regulated. because otherwise we are foreseeing problems in relation to confidentiality. Today, 42 capital A of the Arbitration Act covers the parties and the tribunal. Perhaps the ambit of that might have to be widened to include parties who are funding parties to the arbitration. Then there could be issues of conflict of interest. Today, of course, the Bar Council of India rules don't explicitly prohibit a lawyer from representing the financer as well as the party. But what if during the course of an arbitration there are some issues that arise between the party and the financer? And the lawyer would be knowing, of course, the kind of trade secrets of both parties, which would lead to some ethical considerations. Then there could be an issue of influence over an arbitration that a financer might want to wield, which will affect the partiality of the process, the independence, and may lead to problems in enforcement. And of course, regulating the flow of investment. We'll need guidelines from the RBI if your financer is a bank, the IRDA if your financer is, if you've taken ATE or insurance for as a TPF means, and even FDI policies. What if there is cross-border investment involved, which is the idea now that foreign law firms are also coming in. So I think TPF as a concept needs to be regulated as well. So we need to do this in a little nuanced and calibrated way rather than just injecting TPF in India. Then of course there's a dedicated chapter on MSME arbitration, which is again very, very good in that sense. But I think it's chapter 6 capital A to my recollection. But again, they'll need to harmonize the provisions of this chapter with the existing MSME law, which as per the Apex Code ruling in SILPI has an overriding effect over the Arbitration Act. And of course, lastly, it's the power of the court to modify an award. I think now, of course, we all await the case, the ruling in the Gayatri Balasamy case, but as of now, it's very scattered. You have one chain of rulings starting from NHAI versus Hakim, which says that a court cannot modify an award. You have one chain of rulings starting from Vedanta versus Shandong, which says the court can modify an award. So I think the proposal to insert a proviso to 34(2)(a) is also good, where it says that if an award can be compartmentalized into various claims, each largely, independent of the other, then a part of the award can be set aside. And I think that is good because that will not relegate the parties back to square one. And the court, but again, we have to be very conscious not to make it a court under Order 41 exercising appellate powers. It still needs to be a 34 court. So yes, it's important to do the right thing. The recommendations are great, but it's also important to do it the right way. And let's hope they kind of, shape along well for all of us.
Right. I mean, those are very valid points taken care of in the report, and we'll talk much more about modification. Do anyone else has a quick comment on the expert committee report, if there's anything which we missed out? No? Okay. So, yes, I mean, you spoke about funding a lot and taking a cue from that. And since Shashank has been part of a very progressive and a landmark ruling on tomorrow sales and SPS, which though the question was not in relation to validity of funding in India, Shashank, the question I think was in relation to liability of funders when there's a cost award. So in some senses that matter dealt with a question which is 5 steps ahead of where India was in terms of funding, while we were grappling with the whole issue of whether funding is valid in India or not. That judgment posed a question whether funders would be otherwise liable in case there's a cost award against the party. So, I mean, we'll be very glad to hear your views on where we are. And while we're talking about funding and regulation, you may also talk about ILF, in which you are also a part. So, over to you.
Thank you, Sameer. First of all, thank you, Business World and Ashima, for calling me here. And in addition, I must thank Arush, who's given you the flavor of what is happening around third-party funding in India. Indeed, tomorrow's sales was a landmark judgment in its own set of facts. But I must also give you a caveat that it is pending before the Supreme Court for final adjudication. So what we have, uh, I would of course hope that it doesn't get changed, but it is subject to what the apex court has to say, and it should be heard very, very soon. So let's see if there are further developments around it. But where we are, third-party funding, I think as a concept, I understand we have a very, very mature audience, so I don't have to explain what it means. But whether it is legal in India or not, this question, as Sameer rightly pointed out, does not require an answer anymore with tomorrow's sales judgment, when it has answered questions which are far more nuanced and accepted third-party funding as something that India has to embrace. If India has to become a progressive jurisdiction in the arbitration field. Very basic facts, and before I go on to that, I must say that Sameer is or has been involved in that matter. He was the one who brought the funder in and did that arbitration. So another piece of information which some of you may not know. So the question before the High Court, before the single judge and division bench, was whether there would be any liability of a third-party funder when the third-party funder is obviously neither a party to the arbitration agreement nor to the arbitration proceedings. So, of course, if somebody is not a party to the arbitration agreement, we know the group of companies, doctrine, alter ego, and so many other ways to fix liability if such a party is intrinsically involved in the financial aspects of a litigation. But this is a party who's obviously not a party to the arbitration agreement. He's a funder, steps in when the dispute has arisen, and is also not a party to the arbitration, doesn't take part in anything, and is also not made liable through the arbitration award. But the winning party in the arbitration wanted to recover costs from such a funder in an execution proceeding and in a Section 9 filed before the execution in the Delhi High Court, saying that since the party who has lost doesn't seem to be paying or is going through some financial constraints, please make the funder liable, since funder was the one who really enabled them to conduct this arbitration proceeding. So Delhi High Court, the judgment as it stands today, the division bench said that nothing doing. The funder was not a part of the arbitration. He has not been made liable through the arbitration award, and in Section 9 can only be in aid of execution. When you cannot execute an award against a party, you obviously cannot seek an interim relief against that party. So while deciding this point, there were several references which clarified India's position, or India's growing position in accepting third-party funding as a practical and upcoming norm. Now, something Arush said about regulating third-party funding, I think that's where I may differ slightly. I think most progressive jurisdictions have a self-regulatory mechanism, and in India also we are trying to develop that. There is already an association called Indian Association for Litigation Funding, which has come about a year ago. Still work is in progress, and this is going to be regulating, hopefully it will set out the self-regulation mechanism for third-party funders. But an important point highlighted by Arush, which appears to have emanated from the report, is is confidentiality and conflict of interest. I think for that we would certainly require a wholesome disclosure and a duty of the third-party funder as well as the party using the funder to disclose as and when funding is taken. Institutions have rules for it. In ad hoc arbitration, of course, we do not have any provision in the Act. So, of course, there either through judicial pronouncement or amendment in the Act, there should be a requirement of a detailed disclosure as and when that happens. I can, just to conclude, I can tell you the Delhi International Arbitration Center has already set up a team to formulate rules around third-party funding. So even the Indian institutions are accepting it as something that should be, the next big thing around the arbitration ecosystem in this country. Thank you, Samir.
Thank you, Shashank. I think it's one of the most contextual topics right now, which has an impact on access to justice. So, any other of my panelists will have a view on third-party funding? So, one very important aspect which everyone I think needs to know is the background of what was claimed in this matter was the recent slew of judgments in the UK, where in funded litigations and funded arbitrations, the tribunals and the courts have held the funders liable for cost. The argument of the party who has been awarded cost is always that if the funders are not held liable, and we are dealing with parties which are either pauper or do not have money, there's no use of having a cost award because the parties anyways do not have money. I mean, the counter argument to that is, at least in institutional arbitrations, there's a concept of security of cost, where you can apply to the tribunal to say that, listen, this party does not have money or does not have assets, and in case I was to win or in case I was to be awarded cost, then there will not be any asset against which I'll be able to claim it. And more often than not, the tribunals in such cases award security of cost, and the arbitration will not continue if the party against whom the such order has been made deposits the money. So very interesting question there. And I think with this development, India at least moved a step ahead in terms of making India a preferred seat of arbitration with some clarity. And now when we talk about preferred seat of arbitration, we had recently had the judgment in the curative petition, when the DMRC's judgment, where in exercising curative jurisdiction, the judgment in the civil appeal has been set aside. Now, I want to ask Payal this: is it one step forward, two step backwards, or is it one step forward and plus two steps again? I mean, we have had very, very contrary opinions on this. What's your view?
I don't think that this judgment which has come is going to have any significant impact on whether India is considered a seat or not, a preferred seat or not. And the reason I say this is primarily because the DMRC judgment is being delivered in the context of domestic arbitration. And for those of you who are not aware of the facts, I'll just quickly recap the facts for you. There was a concession agreement between DA, MP, I'll just call it DAMPL for ease of, with DMRC. And there was an arbitration between them, a three-member arbitral tribunal held in favor of DAMPL. And the matter, of course, went up to the Delhi High Court. The learned single judge upheld the award. That was then set aside in a 37 by the DB. And that's very important on what it was set aside. It was set aside on a grounds of patent illegality and perversity. The matter then traveled to the Supreme Court. The two-judge bench reversed the decision of the DB, and they held that the power of the tribunal can have a difference. The tribunal is really the master of the evidence, and they have the right to interpret the contract, even if that's a view that may not be acceptable. This went up in a review and then the curative. Now, remember one thing: at the end of the day, in a domestic award, the patent illegality, that the definition has been widened by Sangyong to include perversity and irrationality. I have long taken the view that this expansion is the issue, because one of the reasons for the expansion is to say that, you know, the quality of arbitrators is not that great in India. That, I think, is going to have an impact, because if you don't trust your quality of arbitrators, why would a foreign party? But I don't think that this curative in that sense is going to have any impact, because the question that the audience may want to ask, or you may ask, is that does this not then set a precedent for it to be expanded to an ICA? I think not, because the parameter for the court's intervention is so small in an ICA. And this is not the judgment that is first opened the door for the curative. So that's in the stamped agreement. And if I may just add one more thing, remember the curative jurisdiction has been exercised under 142. Now, you may say that 142 has been exercised in other matters, but not in a curative. But at the end of the day, in arbitration, in several matters, and going back to McDermott, the courts have exercised power under 142. So.
Yeah, absolutely right. I mean, 142 is the inherent in the Supreme Court's jurisdiction. My only comment, and it's not flowing from me personally, but with a lot of people I've had a discussion with, and I would open the panel and would seek everyone's views. Is it not putting a dent on the whole concept of certainty? While one caveat, I am of the view that there should be some level of intervention in the award because of what we have seen on ground as the awards come out. They are sometimes shocking. So there must be some level of intervention. But at that stage, for the court to interfere, is it not putting a dent on certainty? And I'll just go from this side to that side for everyone to, yes.
Can I just take the first crack at it? And the reason I say no is I think the criticism on the issue is a bit misdirected. That's my view. I think the issue is not so much the curative power as much as, and I'm at the cost of repetition saying, the expansion of the patent illegality test is really where the issue is. If you see the 246 Law Commission, it had never intended for even patent illegality to ever include perversity and irrationality within its domain. So that's where the issue is. So whether the court intervenes at the 37th stage or at the stage of the Supreme Court, or does it in a curative, then those are just additional layers that you're adding. So I think it's a bit misdirected, the criticism. The judgment may have other issues, but this, in my view, is not the issue.
Just a caveat, I'm also Central Government Standing Counsel, so, but the views I'm expressing are completely personal. I would agree with Payal on saying that I think the criticism right now, what I'm hearing from everybody in conferences and events is a mixed bag. And there is some confusion. I think the fair criticism should be on the timing of this. That, okay, you had a 34, then you had a 37, then you had an SLP review, and then ultimately at the stage of curative, the award was set aside. So I haven't really heard anybody going on the merits of whether the award was patently illegal or not, but really the aspect of it being set aside at the stage of curative. So it's that, I think Sameer's question also, that, you know, where are we going with the certainty and predictability, and this can certainly become a standard for PSUs to wait until curative. That would be a problem. If that happens, then even as a state council, I can say we will be in a lot of trouble, because the Supreme Court in its curative also has, while adding paragraphs and paragraphs saying that, okay, this is not a regular SLP, curative is to be used with a lot of caution, we don't encourage curative to be filed, all of this. will still not be enough deterrent for many public sector undertakings to wait until curative. And I think that's really the challenging part. But on the merits of the decision, because it was an award of 3 technical arbitrators, and I have nothing against a tribunal consisting of 3 technical arbitrators, the court found some glaring issues which unfortunately at the stage of curative, the Supreme Court decided to, it just did not pass the test of their conscience to let the award stand.
Thank you, Samir. I think I agree with both Payal and Shashank on this point, because the issue really is not that the award was set aside at the stage of curative, but you actually have to see the background. We are in a jurisdiction where the entire arbitration system is developing at this moment, and we can't expect, or we don't see as counsel also perfect awards, and there are awards which may have glaring loopholes or deficiencies as per section 34. So it's very easy to say that, oh, there is an award, please throw it out, or don't throw it out at the section 34, uphold the arbitration. But the entire focus should be on upholding the justice. If the award is perverse and it needs to be set aside, then stage should not idly matter. So that's something which we should focus on, and also see the background, that because it can't be a straitjacket formula that, in UK somebody says that, oh, we have a very good court system and we don't interfere with the awards, etc. India has a different background, different jurisdiction, and we have to see the things from that perspective and from that background. So I completely agree that, the stage should not matter, and it should not be criticized just because an award has been set aside in curative. And I'm sure that this is an exception, and it's not some, the courts are not going to entertain curative after curative for each and every award. This is an exception considering the background of the award, the facts, the stakes involved. So I don't think that this is something which we can say that we have gone 2 steps back. I think we are where we were.
I absolutely agree with Sonal, because we need to remember that the curative right has always existed. So what DMRC did was just exercised that right. And the Supreme Court in its own wisdom then said, yes, okay, this is a perfect case for a curative petition. So in that situation, that you can't put a blame or consider, because for n number of other cases also, it would be that any party can go for the curative petition. It is not a case where only DMRC was given a right to go for that curative petition. Supreme Court in its wisdom allowed that. Now we are here, and it also caveated to a sense by saying that it will not be treated as a precedent. So it was aware that it may be a very unique case that requires my attention. Having said that, I will not be accepting all other cases.
So while we're discussing Supreme Court, Sonal, I would want to ask you, the recent judgment and then global and the whole quagmire of stamping, registration, unstamped agreements, the debate has been put to rest. But while the debate has been put to rest, as someone who's regularly appearing in both domestic and international arbitrations, as an arbitrator, as a counsel, what do you think is the on-ground impact of that judgment? Is it, are there still open issues? Have you seen tribunals being comfortable dealing with the implications of the judgment?
Yeah, thank you, Samir. I think the recent 7-judge bench judgment on this issue is a big relief, for the arbitration community and also the business community, because if you would recollect, this all started from Judgment Garg, and where the court said that if the underlying contract is not sufficiently stamped, then the arbitration agreement is also invalid, which in my personal opinion was against the basic principle of severability, which is an underlying principle when we are dealing with an arbitration clause. But that judgment was again followed in with the Agarwal, a 3-judge bench judgment, and then came NN Global, a 3-judge bench judgment, which said that, sorry, whatever you are following, I don't agree with that. This is if the underlying agreement is not sufficiently stamped, it should not impact the validity of the arbitration agreement, which was, according to me, correct proposition. But because there was already a 3-judge bench judgment, it was referred to a 5-judge bench judgment, and with the majority of 3-2, the court again said that if the main contract is not sufficiently stamped, the arbitration agreement goes out of the window. You can't, it's an invalid agreement. And it also added that the courts will test this at the stage of Section 11. So, and that was a major concern for a lot of businesses. Maybe not for law firms and lawyers, because we were, approached by so many companies, and they were in a fix that what to do with their contracts, agreements, approaching the concerned authorities for stamping of the contracts. But it was complete mess as, from the perspective of the corporates and the business houses, because there were several contracts and issues like, which state, stamp duty differs from state to state, which stamp act or which, state, according to which state they should impose stamp duty. So all those issues have crept up. But thankfully, the Supreme Court, I mean, this matter was again referred to 7-judge bench, and Supreme Court was very swift in acting and overruling this. And finally, it has been decided, saying, in the 7-judge bench judgment, the Supreme Court has created that distinction between inadmissibility of a document and validity of a document. So they say that if the underlying agreement is not sufficiently stamped as per the Stamp Act, it could be inadmissible, but you can't say that it is void or it is invalid. So because, again, relying on the underlying principle of severability. So now that has brought some clarity, for the business houses and counsels and arbitrators, people who are sitting as arbitrator. But also the Supreme Court in that judgment said that if the arbitrator feels that this needs to be stamped, then of course that can be taken up, and that those issues, it can be sent for proper stamping. In my personal opinion, after that judgment, I think that lawyers and arbitrators are pretty relaxed, and I have not seen arbitrators sending those agreements for stamping, and the process has been smooth. And the most important part is that the courts are not interfering at the stage of Section 11, because in that judgment, the Supreme Court also emphasized that at the stage of Section 11, you can only see the existence of an arbitration agreement, but cannot go into issues like non-stamping. That will also be against the Section 16 doctrine of competence. So I think right now that 7-judge bench judgment has put those issues which had arisen earlier to rest, and the field is pretty much comfortable for lawyers, arbitrators, and business houses.
I just have one thing to add over here. I mean, there's a little bit of a practical concern as an arbitrator. So now the buck has been passed on the arbitrator, because issue of stamping being an issue of admissibility is within the remit of a tribunal. But if you look at 38(1) and 38(2) of the Stamp Act, because we're still bound by the Stamp Act as arbitrators, if at the stage of the evidentiary hearing, an unstamped instrument is not going to be admissible. Now, yes, as an authority with the consent of the parties to receive evidence, I have to impound the instrument. But in practical reality, what teeth does an arbitrator have to impound that instrument? I can at best prepare a letter saying that please impound this, please adjudicate the appropriate duty leviable on this instrument. How more meaningful or more binding is that for the stamp authority as opposed to a party doing it? So ordinarily what tribunals are now doing is let the claimant or the respondent, in most cases the claimant, give an undertaking to adequately stamp the instrument. But that has to also be factored in 29 capital A, because I can't have control over when the stamp issue, because right now I'm doing an arbitration and everyone is saying that all the concerned authorities are on election duty. So there goes 2 months, and my meter is is down in that sense for 12 months under 29 capital A. So that kind of clarity needs to be given, because otherwise we will end up delaying the process further.
A fair point, but I think yeah, all these teething points will be more, clearer when high courts take over these issues in matter-to-matter basis.
I don't want to eat it too much into anyone's time, but I'm sort of married to this matter because I had the pleasure of appearing in that
Yes,
matter. So
fantastic.
I'll just see, it's not going to be very different whether the court did it, because it's the same amount of time, right? So, but I think may just add one thing which was, which already Sonal has alluded to. It's a very, I think for everyone here, it's a very interesting issue which weighed in with the court as well. At the issue of stamping, if you say that the document is invalid because it's a curable defect, if you pay stamp, something that's void is never resurrectable. It's void and then dead at its heels. So this is something that was, that is just an interesting law point which you all might want to think about.
No, that's
Because
food
the
for thought.
five-judge bench had said,
Yes.
right?
Coming to the next point, and I think most of us who've appeared as counsels or made filings have had experience of dealing with some defective filings of 34 and the whole issue on timelines and are you saved, are you not saved, and refilings. Now, Delhi High Court has recently referred this question to the larger bench whether some form of defective filings can be considered as non-est, meaning thereby that you do not get saved on time and it will not be considered at filing at all. So my question is to Mehul on this, as what are the, what exactly is the question which the court wants to get answered, and what kind of filings could and should be considered as non-est, therefore not triggering your timeline under 34?
Thank you for your question, Samir. It may seem like an innocuous question at first blush because it's very procedural and technical. Our clerks may do it and let's just go ahead and finish it. But the flurry of judgments and matters before the High Court in the past 12-15 months has made it a very relevant question. So to answer that, it can be, I think, divided into two buckets. First is with respect to a fairly well settled principle about the mandatory nature of limitation under Section 34. It is an interesting point there is that it is divided into two parts. First is an initial period of 3 months and then an additional period of 30 days. Now usually what people end up saying is that, oh, there is a limitation of 120 days. That may not be right, considering the fact that if, for example, you're in the month of February or July, the time period could be 121 days or it could be a 118-day period. So, but at the end, fairly well settled that it is a mandatory period. The moment you skip it, your right extinguishes. Now coming to the question regarding non-est filing. What is non-est filing? Again, the High Court in a plethora of cases has held that it shouldn't be a bunch of papers that you file merely to defeat limitation. It has to be something when the court or the registrar reads, it has to come out to be a Section 34 petition. It just cannot be a bunch of papers. Now, what are the essential principles of a 34 petition? You must have an award. So if you don't file an award, of course it is a non-est filing. Second, the grounds of challenge. If you don't have a ground, if you've not put in the grounds on which you're challenging the award, again, it is a non-est filing. Issues actually come when you start dealing with slightly procedural aspects. Was there a wakalatnama filed? If filed, was it signed? If signed, was it signed by the person having a board resolution or a power of attorney? Was there a power of attorney or a board resolution present before the, with the petition? And now the question of statement of truth also comes in. Now, as we know, statement of truth was introduced by the Commercial Courts Act and then incorporated by the amendment to the CPC. Order 6, Rule 15, capital A, if I'm not mistaken, talks about a statement of truth. Now, what is a statement of truth? It is essentially a fatter and meatier version of an affidavit. It has all the principles and essentials of an affidavit, including 2-3 other statements, such as the number of pages in the petition are X, all documents are certified copies or original copies or copies of the certified copies, and then you sign it. It has to be stamped. There should be a company stamp, and then it has to be notarized by a notary and an oath commissioner. Now, what happened before the Delhi High Court recently in April was that a statement of truth was not filed with a 34 petition. So in the case of Bharat Broadband before the single judge, both sides put forth 2 decisions of the division bench. One decision was in Sairama, in which the court said it is merely a procedural defect. Therefore, I'm allowing it because from your petition, I can make out it's a 34 petition. It has all other principles and all other requirements are fulfilled. Therefore, the mere filing or non-filing rather of a statement of truth is just a procedural defect. I'll let it go and I'll allow your refiling, and there is no, and I'm allowing a condemnation of delay. Subsequently, last year, the division bench in Planet Cast held that if you read the CPC as amended by the Commercial Courts Act, and as all filing lawyers at least before the Delhi High Court would know, that the Commercial Courts Act is applicable on all matters pertaining to section 34, 37, so forth and so on. It said that since it is mandatory, because the wordings used in the in Order 6, Rule 15, capital A, make it mandatory, therefore it is not just a mere procedural defect. It is a defect which is inherent. You've not filed it, the statement of truth, therefore it is a non-est filing. Now these 2 decisions were placed before the learned single judge. The learned single judge was of the view that this requires an authoritative decision, and he's referred the matter to be placed before the Chief Justice, and in all likelihood the Chief Justice would be setting up a full bench of 3 judges.
Right.
It's been done, I believe.
Just before we close this question, I think the judgment in which it has been referred was Shashank's judgment, so it's very imperative for you to.
Yeah, so there is a further update in this. Another decision has been referred to larger bench that was recently done.
Bharat Broadband.
No, this is in my case where I was appearing for the Union of India. Before the division bench. The division bench, of course, was looking at its own Sairama judgment and a coordinate division bench's Panacea Biotech judgment. The question really that now has been sent by division bench to larger bench is whether non-filing of an award in itself is a non-curable defect, because the division bench was referring to the reasoning in Sairama to say that all of these defects have to be seen cumulatively, and if it is an intelligible filing, one of the defects cannot be isolated to say that, okay, if you've not filed the award, you're out. So on this question, there has been a further reference, and this was as recent as 4 days ago. So even non-filing of an award, this question has been added to the list of questions now that will be answered by the larger bench.
Basically, 1 step forward and 2 steps back, because if the question of non-filing of an award is also before the full bench now, or the larger bench is.
Right.
Just to conclude, I just also wanted an interesting question came up in one of our matters regarding non-est filing, was the applicability of what kind of rules, whether it is the original side rules of 2018 that will be applicable, or as we would know, there in the Delhi High Court website, there are a certain other Delhi High Court rules and orders which are available just on the website. So the main difference between the two is that in the original side rules, after 30 days aggregate for refiling finishes, you can still approach by filing a condemnation of delay before the registrar. However, this was missing in the Delhi High Court rules and orders, in which it stopped at 30 days filing. So in our case, the learned single judge actually relied on a division bench judgment to hold that the original side rules would supersede, considering they were later in time. They were prepared under the Delhi High Court Act, and there is a non-obstante, notwithstanding clause, which gives them superseding powers. So just so that everybody knows, this was
Thanks, Mehul. Um, we're short on time, but I must also talk about Section 34 and 37 Court's power to modify an award, and I think there's a lot of debate on whether modification should be allowed, whether India is ready or India needs it, what's the situation globally. Divyam, my question is to you, and there has been a reference by the Supreme Court on this question, but more conceptually, do you think India needs a modification power, or will that be too counterproductive for India?
Thanks, Amir, for the question. First of all, thanks, Dr. Batra Ashima, for inviting me. I know I'm on borrowed time right now, so I'll be...
No, you're not. I will take that liberty. So please go ahead.
Okay, so I'll try to be quick, but cover the point. I think the discussion needs to be, and it's like, let me divide it into a spectrum, which starts from a very strict view that you can either set aside the award in full or partially. Then you move a bit on the lenient side, you go towards an aspect of severability. Then you move further, then you go to a situation of Article 142 being made applicable to do substantial justice. Then you move further, you go to a sort of a modification only limited to the extent, let's say, of an interest component. And then finally, the end is where you decide to modify an award. So that's the spectrum we are looking at. In that, Hakim, which is Arush mentioned, NHI versus Hakim, is a judgment which is somewhat in the middle, where Justice Nariman, while going through all the case laws, decided that you cannot modify an award. What you can probably do is to partially set aside or sever a portion of the award. You cannot modify, yet interestingly, Supreme Court, while passing its decision, exercised 136, 140 to actually modify the award. So that was the interesting aspect. So what I will like to point out is that the word which Justice Nariman used, Lakshman Rekha, I like to add a phrase to it. I'll say that now the position in which is what the larger bench is likely to see is a Lakshman Rekha versus Dharam Sankat. So Lakshman Rekha is a situation where you don't want to transgress into the boundary of arbitration, you want minimum judicial intervention, you want a finality to be achieved, as opposed to doing a substantial justice. Consider a situation where you are not in a position to partially set aside the award or to sever any particular portion, but it's not ultimately doing substantial justice, so you're not left with a choice to even modify it. So I would say a fine balance needs to be drawn between them. There have been instances where courts have exercised this balancing act by, though minimum to aspects of interest component, as I pointed out, there are judgments to that effect where they have exercised it. There are case laws where, and in fact, I would refer it to what Justice Yashwant Verma did in NHI versus Trichy, that he said that you can sever a part of the award. You should exercise the concept of severability. If you can actually devise out of a particular claim, that part can be removed. So I think it is all about striking a right balance. As I said, you cannot take either of the end of the spectrum and be happy with it, because somewhere or the other you will face a situation. I am currently faced with a situation where there was an arbitral award. Out of 13 issues, 12 issues were decided in my favor. It was a specific performance versus a damages case. Ultimately, the damages, they gave nominal damages and be done with it. My client challenged it 34, 37 now in Supreme Court. Supreme Court is in a position to see whether that damage quantification, can they go into this aspect at the stage of a 34, 37 and later on in 136. But we are left in a situation that either they send it back let this issue after 15 years again be decided by an arbitral tribunal, creating a huge amount of delay, or the Supreme Court gets into the aspect of a judicial intervention of sort and says that no, let me for do substantial justice by fixing a sum around the damages, or let me appoint an expert who will determine it. So let me partially set aside this, or if possible, let me modify it. So it's all about striking the right balance. As I said, and time is less, so I'll just simply say it has to be a balance between Lakshman Rekha and a Dharam Sankat.
Now, I am on borrowed time, and Ashima, I am in a Dharam Sankat, whether to cross the Lakshman Rekha of this to ask 2 or 3 questions from the audience.
Yes, absolutely. We have some questions waiting for the panel.
Fantastic. Thank you.